Good morning, ladies and gentlemen. Welcome to this first breakaway session of the conference that's on global environmental law at the Crossroads. We have 4 papers, 4 speakers. 2 deal with global international law, and 2 deals more with environmental or local governance in their own countries. 1 from South Africa, 1 from China. I've asked each of the 4 speakers to speak more or less, or preferably less, 15 minutes. And then they will follow on one another, and then we will have time for discussion at the end. So please, if you have questions for the speakers, please note your questions or whatever you would like to contribute, and then we will have a discussion at the end of this, so that we have proper time for discussion and not one person taking up the time from the other speakers. Our first speaker will be Arnel du Plessis from the Northwest University in South Africa, following by Louis Kotze, also from Northwest University in South Africa, and you will see that we are very much, all of us from that area. To move away from us, we have Andrew Long from Florida Coast School of Law in the USA, sorry, I have difficulty pronouncing your name. We're from Shanghai University School of Law in China. And I will ask Arnel then to speak and introduce your own topic. Thank you.
Good morning, ladies and gentlemen. I'm not going to be one of those speaking less. I'll try my very best to be on the spot. So I'm going to start without any further ado, just perhaps saying that something strange happened to the title on the program, the correct title you see up here. Most environmental lawyers are aware of the distinction between the so-called brown agenda and green agenda in environmental governance, but it's those focusing in their research on the dynamics of local urban environmental governance that will be most familiar with ongoing concerns about authorities' efforts to get the brown agenda right, especially in the developing country context. The brown agenda is by nature anthropocentric, as it essentially aims at the reduction of threats to human health and well-being. Although international environmental concerns have become very green, and we've just heard that again this morning, the impacts of brown agenda type problems on the poor and the vulnerable in relation to local level governance are still globally discussed. Sorry about this. However, the deeper repercussions of persisting material inequalities for achieving, amongst others, the objectives of transformative constitutionalism and social justice as prerequisites for sustainability in nation states may not always be immediately clear, and I'm trying to look at that in brief during this presentation. While admittedly some great work has been done in various areas, increasingly also in the areas of climate mitigation and energy efficiency, and Wilhelmine will be talking about that in her presentation, a hybrid of interrelated political, resource-related and other socioeconomic challenges underpinning the political processes of local governance, the level of municipalities, may be blamed for what has now become known as failing municipal service delivery. The pervasive link between municipal service delivery and local environmental governance, as such, suggests that 16 years into our country's transition, local environmental governance finds itself at a crossroad. There appears to be serious underestimation in local government of what it takes to effect transformative constitutionalism and social justice, and by implication there's a skewed appreciation of what exactly is required to set and keep the brown agenda on track. In this paper, I'm but touching on the tip of the iceberg in questioning whether municipalities' adoption of corporate governance principles may be a solution to what has essentially become a brown agenda problem. This is my image for corporate governance. Between 2009 and 2012, a growing mix of cases dealing with serious brown agenda questions in the urban poor context, ranging from issues of access to water, including communal taps, access to basic sanitation, refuse removal services and high-mast lighting, to infringements of several human rights, including the right of adequate housing and the environmental right, appeared before the highest courts in our country. All of these cases were brought either against a metropolitan or a local municipality, and all of these cases implicated, irrespective of the outcome, ineffective approaches to local environmental governance, with local authorities being perceived as unresponsive, non-transparent, unable to meaningfully engage with local communities, unable to see to intergovernmental coordination, and so forth. Due to time constraints, I'm not able to sketch the detailed context with reference to the relevant cases, but it merits to briefly mention one of them. In what has become notoriously known as the case on a loo with a view, the court had to decide in Dabeja versus the Western Cape province a brown agenda type case, which involved the city of Cape Town. The city, as part of an interim arrangement installed in 2007 in a big settlement called Kaalicha, almost 1,400 communal toilets on a ratio of 1 toilet for every 5 families. Makaza is an informal settlement, part of this area of Kaalicha, and is characterized by severe poverty, with only the most basic of services available. After engagement with the community and input from a small group representing the Makaza people, the city changed the project in order to provide individual yet unenclosed toilets, and you see that up here on the screen, instead of the communal facilities. Some community members had the necessary means to enclose these constructions, while others, almost 60 families, didn't, with the result that some people, including women and children, had to use these unenclosed toilets, covering themselves with blankets, and the toilets amounted to nothing but a concrete slab for the toilet to stand on, with a cistern and a water pipe that was not affixed to any walls. After various unsuccessful attempts to engage and reach agreement with the city, the community approached the Western Cape Province, the High Court, to declare the conduct of government in providing these open toilets to the community of Makaza to be in violation of a whole range of constitutional rights. In arguing their case, the applicants relied on the values of the Constitution, which included human dignity and the achievement of equality. In addressing this matter and indeed deciding in favour of the community, the court reminded the parties of South Africa's commitment to constitutional transformation, the MDGs and various UN declarations. Important, what was implicated, and this is what I want to get to, but was not judicially considered, was the systemic problems with municipalities' engagement with communities, their reasonable appropriation of municipal funds, and openness with respect to local councils' decision-making processes. In a subsequent investigation by the National Department of Performance and Evaluation in our Office of the Presidency, it was found that the key factors affecting the prevailing poor progress in the provision of sanitation services, among other services, the key factors affecting the prevailing poor, it ranged from, fragmentation of responsibilities for sanitation, unclear performance standards, lack of technical capacity at local government level, resulting in poor planning and neglect of operation and maintenance, to insufficient financial planning and management, leading to inadequate budget allocations, inappropriate use of allocated funds, and a weak system of revenue management. In addition to the above, the Public Service Commission recently submitted to Parliament an assessment of service delivery across government, including in the areas of the creation of sustainable livelihoods and the improvement of health, issues falling squarely within the governing domain of local government. The Commission reported that despite South Africa having a major expanded public works program, and I quote, "a profound disjuncture between spending and performance." Some of the key problems were found to include the lack of setting of quality and levels of performance in government, and the overall lack of inclusive performance audits, government spending not corresponding with the achievement of targets in terms of duties and functions, the awarding of bonuses which do not correlate with performance, the overwhelming tendency to use consultants in the execution of core functions, so privatization of certain functions, and the lack of internal skills development with problematic financial management accompanying those. What is worrying is that the move towards social transformation, for those of you that have been in the country, relies intimately on minimal levels of, amongst others, effective environmental governance in municipalities. This is a running theme in contemporary socio-economic rights literature, but yet, in the South African context, execution and progression of local environmental governance remains under severe pressure, and inefficiency in municipalities continue to have serious consequences, one of which is ongoing service delivery protests. One may look at this problem from various angles. And large volumes of interdisciplinary works exist on the turnaround and improvement of governance generally. I would like to turn in the remainder of this paper to recent developments in the quasi-legal sphere with respect to public governance, considering by way of introduction the transferability of corporate governance principles to public governance, including local environmental governance. The King Report is a corporate governance code in South Africa. It is effectively a summary of the best international practices in the area of corporate governance, and all companies listed on the JSE, the Johannesburg Stock Exchange, must, for example, comply with its provisions. The first of the three reports was published in 1993, 1 year prior to the first democratic elections in South Africa. It was chaired by a committee, or it was designed by a committee chaired by the retired Supreme Court Judge Mervyn King, and the reports followed a principles mixed with practice-based approach to corporate governance. Unlike a number of similar codes in the world, the King Report is non-legislative and developed along the lines of an apply or explain as opposed to a comply or explain approach. The overriding philosophy in the King Report is based on leadership, sustainability, and good corporate citizenship. While King 1 was drafted as a recommendation of standards of conduct for the boards and directors of companies listed on the main board of JSE, banks and other financial institutions, all companies in South Africa were from the beginning encouraged to adopt the code. It focused on financial and regulatory aspects of the operation of companies, but also called for an inclusive, integrated approach to corporate governance. King 2, published in 2002 during the Earth Summit, included new sections also on sustainability. King 2 for the first time introduced the idea that public and private bodies must comply with its principles, extending its scope of application to government. King 3 was released 7 years later in 2009. To rectify one of the biggest mistakes Mervyn King believed has been made with King 2, namely to include sustainability as a separate chapter in the initial reports, which led companies to approach sustainability in a silo-based way. The fact that King 3 also applies to the public sector, government, is significant. The report encourages the private and public sectors to adopt and apply its provisions, and then to explain why these have been applied or have not been applied to and or may not have been applicable. So what? What could possibly be the link between a set of principles using jargon and examples that speak in essence to decision-making in high-rise glass buildings in Cape Town and Johannesburg, and the municipalities of Tlokwe, Mangaung and eThekwini, responsible for providing local people with basic access to water, sanitation and adequate housing? I regard three of the international or emerging governance trends incorporated in King 3 as potentially relevant to the critical evaluation of local environmental governance from a Brown agenda perspective, namely integrated sustainable reporting, alternative dispute resolution, as a management tool, and a combined good governance assurance model, which makes provision for inclusive internal auditing that's not limited to financial aspects. Due to time constraints, these cannot be fully discussed. It suffices to say that A, compulsory financial reporting by municipalities since 2003 went a long way in making public the reasons and people behind poor financial management. Integrated reporting on progress with sustainability deliverables, something as basic as the provision of toilets, may potentially have the same effect, providing communities with information on local government planning and spending, also in relation to Brown Agenda type targets and objectives. B, the development of alternative dispute resolution as a means of needs-based settlement of conflict over government spending and the provision of basic services and other amenities would make the resolution of Brown Agenda type conflict more accessible and cheaper. It may also reduce the social and physical harm caused by public service delivery protests as the popular means of voicing frustration at the moment. And C, audits conducted by an internal yet independent auditing committee would enable the accountable officers and top decision makers in local government to identify and rectify problems such as poor compliance and performance before public damage is done, while it would also generate the type of information necessary for integrated sustainability reporting. The proverb reads that the measure of a man, and in this instance the king, is what he does with power. I fully agree with Steve Cornelius and others who argue that there are corporate governance principles that may apply across a broad range of legal, economical and political environments. But David Satterthwaite, known for his extensive research on urban environmental governance and sustainability, together with others in a 2006 report, warned as follows: how a problem is conceived influences any solutions that may be developed, and whether solutions work depends not on whether the right solutions are identified, but also on whether there are organizations capable of supporting the implementation. For Africa, far too little attention has been given to supporting the local organizations on whose performance solutions to most problems depend. These include local government. Even when attention has been given to this, it has often been to try to recreate inappropriate models because they worked somewhere else. End quote. The concern in this instance is directed at the transplantation of foreign countries' and regions' models of governance, and not on the transplantation of governance models, i.e., public and corporate governance within the same national context. Still, trying to be the type of critical environmental lawyer Paul Martin called for during Saturday's workshop, I declare myself hesitant with respect to the viability, at least at this point of the research, of the one-size-fits-all type of transplantation of corporate governance models to local environmental governance specifically, and the main reasons being the following. The relationship between politicians across 3 spheres of government and within a single municipal council, between politicians and officials, as well as between political office bearers and the electorate, is a relationship premised on a social contract, the Constitution of South Africa. The fundamentals are entirely different from the relationships one encounters in the private sector. No municipality can be regarded as a corporate citizen in the true sense of the word. Even though it is a juristic person, a municipality stands in a relationship with citizens that's infused by state power. The reason also why Clatworthy and others have been arguing that the nature of a managerial stewardship is far stronger in the public sector, since in the private sector, a dissatisfied user is able to sever their connection with the entity, whereas in the public sector, such a choice is simply not available. The first King report, on which all subsequent reports were based, came into being before the first democratic elections in South Africa, and the vision for a new corporate governance model was accordingly never designed to meet very unique governance demands that would arise in an entirely transformed new local government dispensation. The report does not cater for historical segregated development and the service delivery backlogs that resulted therefrom. It does not cater for frequent changes necessary in the strategic planning of government due to an unprecedented influx of immigrants from neighboring countries, and it does not cater for the slow progress with the total reconstruction of the revenue base of local government. King 3 speaks to a Western conception of governance that may be suitable for local governance in many of the urban municipalities of South Africa, in at least 3 of the 9 provinces. But the report does not mention, apart from its reference to Ubuntu, how corporate governance principles speak to traditional governance systems, while traditional leaders in the rural areas of the country form constitutionally part of local government. This raises questions about the urban and rural divide, as well as between the government and traditional leadership dichotomy. And while the Brown agenda speaks mainly to the urban context, the latter problem shows how the scope of the King report was rather impetuously and without proper research extended in 2002. Of utmost importance in local government in any democratic dispensation is public participation and meaningful engagement with communities. King 3's principles speak of inclusivity and engagement in corporate jargon, which does not help in guiding public participation in the true sense of the word, an issue that's highly relevant from a Brown agenda perspective generally. And finally, questions not answered by King 3 include to whom would the internal auditors of a municipality owe their duty of care? And further, municipalities cannot be listed on the JSE, and community members may not voluntarily invest more property tax, for example, by virtue of their municipalities being King 3 compliant. Why would any municipality go through the trouble of attempting to apply King 3? Despite what may seem as total skepticism towards the King 3, what King 3 proposes to achieve, I do think that its principles, expanded scope of application and focus on sustainability is opening up important opportunities for local environmental governance. The transferability of governance models between the private and public sectors is questionable, but this does not render any comparability void. It's agreed with Clatworthy that rather than transfer private sector governance models and attempt to adapt them to different circumstances, municipalities are sufficiently heterogeneous to justify the establishment of a distinct corporate governance model, i.e. for local government. Even with local government, within local government, the differences between different municipalities may have to be acknowledged, and as is clear from the variety of codes of governance for the private sector that exist all over the world, and from the varying levels of performance in the 284 municipalities of South Africa, this would be preferable. In conclusion, an unresponsive and non-transparent government at whatever level that's unable to meaningfully engage with local communities and the governed is nothing but a threat to the function and success of any environmental law regime. The Brown agenda is the core business of local government in South Africa and in many other countries of the world. Exploring the lessons learned from corporate governance models seems to be one way for scholars like ourselves and governors to figure out how to realize and effect the promises of environmental law for the most vulnerable and the poor. Thank you.
Thank you. And now, Louis, can you come, please? Can I please ask the speakers to adhere to the time limits and to the timekeeper, please?
Thank you, Chair. Good morning, everyone. It's really a pleasure to be here. And in this paper, I would like to address the issue of the emergence of global environmental governance law. The focus of this paper is on a research project of mine, which is ongoing. I've had the pleasure last year to write a monograph on global environmental governance, which I'm happy to say will be appearing in September with Edward Elgar. And this is a further extension of this project. I'm also very grateful for the extensive comments by friends and colleagues who are here in the audience, Professor Jonathan Verschuren, Afshan Akhtar Kavari, and Benjamin Richardson on this project. Now, what I would try to do here is just to sketch the broad parameters of what I understand to be the context of an emerging new body of law. In the monograph that I mentioned, I described global environmental governance as a normative institutional regulatory intervention and a social construct that aims to influence how people interact with the environment in the global. It entails a pluralistic, dynamic, multi-level, multi-actor process of change, which idealistically aims to optimize environmental benefits and use, while at the same time seeking to equally protect environmental capital for the benefit of present and future generations. Importantly, law is a crucial part of and plays a critical role in global environmental governance, as we know. Law is the constitution of global environmental governance. Law legitimizes global environmental governance. It creates global environmental governance actors and allows them to govern. Law provides the authority to these actors to govern. It prescribes how to govern and what to govern. And law provides the minimum legal thresholds for what is deemed acceptable and unacceptable societal behavior towards the environment. So law, therefore ultimately fulfills a distinctive constitutive, legitimizing, prescriptive, proscriptive, instrumentalist, and guiding function in global environmental governance. Environmental law could arguably be considered the primary body of rules in global environmental governance, as we know. Yet, in tandem with the globalization of law, alongside a continuously disaggregating global environmental governance effort, numerous other types of legal rules are assuming increased importance in global environmental governance. And these include, for example, investment law, international organizational law, administrative law, and a host of reflexive, informal, non-state, yet law-like rules, such as the Equator Principles. So the hypothesis of my current research project is that traditional environmental law at the various levels cannot continue alone to fulfill the functions that law must fulfill in the broader paradigm of global environmental governance. While environmental law will no doubt remain the predominant body of law in global environmental governance, the emergence of a more coherent body of global environmental governance instead requires an extended view of law in the global. Now, this paper proposes that global environmental governance law is a more suitable phenomenological conception that could cater for the diverse needs of disaggregated global environmental governance. It is an emerging, amorphous body of law, and it could include any subdiscipline of law to the extent that it is relevant to facilitating global environmental governance or to achieve the objectives of global environmental governance. Global environmental governance law thus transcends and recasts the traditional disciplinary boundaries within and of law, the traditional geographical delineation of national, regional, and international levels with respect to law, and the traditional sources of law into global rhetoric. It also necessitates rethinking the regulatory link between law and the objectives of law in the global environmental regulatory domain. Global environmental governance law must first and foremost be understood in the context of the global. And why is this so? Because the global helps one to understand the complexities of the governance phenomenon as it manifests in the context of globalization. It acknowledges the interconnected, universal, holistic, and transnational facets, characteristics, and problems of a globally conceived environment. And it informs, importantly, the type, content, extent, and design of our regulatory responses to these global environmental issues. So global, perhaps not surprisingly, has its roots in the setting of globalization. Global in this context would mean what Ford calls, and I quote, an orthodox spatial definition, where it's used as a causal category that posits that environmental degradation is global because it's caused by social, economic, and political relationships and structures that are global. There is no single sense in which an environmental issue can be described as international. It could be regional, transboundary, domestic, or a combination of all of these. And the combination of all of these, for me, is the global. When considered in the context of globalization, this would entail that what occurs at the subnational level could have an effect on what happens at the sub-regional, regional, and international levels, and vice versa. Here we observe a very distinct characteristic of causality. Global, thus described, by implication refers to the local, the national, the regional, and international, both in a spatial and a causal sense. In addition, Maria Ivanova explains that governing human relations has become a very complicated endeavor that has transcended the national and international scale and moved to a global level involving multiple actors. Global in this context refers to deterritorialization. It indicates, among other things, that governance can occur at all levels simultaneously. By implication, deterritorialization means that governments and states will not always be the sole actors in governance anymore. Global, therefore, also implies a kind of multi-levelness, and where it is used to refer to multiple actors. In other words, the word global is therefore used as much for its geographical connotation as it is used for its omission of the state and for referring to the causal effects of the globalized processes. An expanded view of the environment is as important for law and governance as the global context is, in an effort to describe global environmental governance law. This is because the nature, extent, and severity of environmental problems today require of us to rethink our institutional responses to these problems. To quote Shams, because legal and governance structures must adjust to accommodate broader notions of the environment, we also need to be innovative and sufficiently comprehensive in our definitional endeavors that seek to understand the environment. Or as Caldwell states, at the end of the 20th century, the world is in an unprecedented transition. The adaptability of present institutions to emerging challenges is being widely questioned. In a broadly encompassing context, these areas of challenge have environmental implications, and this assertion is credible only if the environment is understood in its holistic dimension, in all of its complexity. I would propose that no single social institution, including law and governance, which I understand to be social institutions, could comprehensively and on its own encapsulate the environment, or more precisely, entirely could address the environmental problem. Instead, the environment's dynamism, amorphousness, and multidimensionality, by necessary implication, require that the environmental agenda be equally dynamic, amorphous, and multidimensional. The rather uninspiring conclusion is therefore that there probably cannot be a single, universal, accepted definition of the environment. For the purpose of law and global environmental governance, what would be important is to acknowledge that over-inclusiveness is better than under-inclusiveness. In this context, Godden and Peel's notion of the many environments is appealing. How do I go back there? Is very appealing because it helps to situate the environment and environmental problems in the global context. And they say that it's possible to conceive of multi-layered, multidimensional environments that intersect and overlap to make up a unitary phenomenon. These environments might range from the local to the national, to the regional and the global scale, from a single species, from indigenous cultural heritage to partnerships between environmental non-governmental organizations, for example. So attributing the meaning of many environments to the environment in global environmental governance would render it sufficiently reconcilable with the global in global environmental governance. And it would be particularly accommodative of the indeterminability of global environmental governance. What do we understand under global law? In the same way that governance has become global, so too has law been freed from its national and state-centered shackles in the attempt to deal with or regulate globalization and its consequences. To be more precise, law has become global because, first, it is created and enforced at various levels, including the subnational, regional, and international. In many instances, these levels are either connected or are at least mutually receptive to reciprocal influences that flow from the one to the other. For example, international law influences the design and content of national legal developments, as we know, and its success largely depends on effective national implementation. Conversely, domestic legal rules have the potential to influence environmental law, international law, and there are many examples in this respect. Second, law is global because today it's created and enforced by multiple actors. Third, law is global because as a result of the plurality of these actors, the nature and types of legal rules are also changing to include very strict hard law and less strict, softer, yet law-like rules. And the example that I gave earlier is the Equator Principles, for example. The general criteria to measure the emergence of global law, in addition to the fact that it must be multi-level to a greater or lesser extent, is whether or not it has moved beyond the interstate paradigm. Environmental law, by all counts, have become a multi-level enterprise. But has it moved beyond the state? The law that regulates environmental issues today is a mixture of state and non-state law that manifests at various levels in the global. Environmental law in the context of the many environments, as we've said earlier, has thus moved beyond the state, both in a geographical sense, but also in terms of the levels and the actors involved. And to make a long story short, I think it is therefore possible also to identify and to speak of a very distinct form of global environmental law. Now, the emergence of global environmental law against everything, the context and the background of what we've said, perhaps more than anything else, emphasizes the point that international environmental law as such cannot be the sole component of the legal response that seeks to address the global arena's many environments today. Neither could regional laws or national environmental law systems be the only legal institutional responses to the global problems we face. Put differently, international environmental law has become inadequate to fill the shoes of global environmental governance. Certainly its legal foundation. The regulatory consequences of globalization instead involves polycentric global environmental governance, which is multi-acted and which is multi-level. This means that there must also be a body of law that makes global environmental governance work, as it were. Now, if global environmental governance, to conclude, is understood as an institutional response to global environmental problems, which includes the entire collection of normative arrangements at all these levels that we've set, which are created, maintained, and enforced by state and non-state actors, then it might be possible to describe the collection of these normative arrangements that manifest in the global context and that applies to the many environments as global environmental governance law. It includes national, regional, and international law. It is hard and soft, coercive and reflexive, and it is made, interpreted, and enforced by states and non-state actors. Importantly, global environmental governance law could include environmental law, pure public international law, economic law, trade law, global administrative law. In fact, it is an emergent body of law, as amorphous as its parent concept, global environmental governance, is. And it could include any subdiscipline of law to the extent that it is relevant to facilitating global environmental governance, or to the extent that it could change human behavior in the global towards the environment. An inquiry into the existence and parameters of global environmental governance law is not a mere academic exercise, although I do realize that it might sound like one. Determining whether or not some form of global environmental governance law exists also tells us something about the manner in which law operates. specifically in the global environmental governance paradigm. To quote Agard, "We designate legal fields, environmental law, labor law, criminal law, on the premise that those designations identify something important about how the law operates. Moreover, it tells us something about the legal foundations and legal rules that constitute, legitimize, prescribe, proscribe, and guide global environmental governance." While such a broad description of global environmental governance law, such as this paper has proposed, may seem not particularly useful to legal taxonomy and to pragmatic considerations, it does force one to resituate the role of law in the global environmental regulatory context and to face the modern realities and challenges that the many environments in the globalized context require us to do. Thank you.
Thank you, Louis, also for sticking to the time, Andrew.
Tricky thing here.
It was, but I just made a small change. Good morning. I want to thank the organizers of this excellent conference for inviting me to speak. And my presentation will hopefully pick up on one of the themes that Professor Coetzee raised, and that's in particular the need for a more polycentric approach to environmental issues in the global space. And also a related component, I think, is the need for greater linkage in the way that we regulate the various issues that comprise the subject of environmental law. So the theme of this conference is global environmental law at a crossroads. And I think that most of us would agree that the globalization of environmental law has led to a number of improvements in environmental law throughout the world, through borrowing, through learning what other nations are doing, through learning at various levels of environmental law. But it also highlights, as the previous presentation made clear, the shortcomings of our existing efforts to regulate at the global level. Right? Good examples of this, well-known examples, are the efforts to regulate climate change, and perhaps most disturbingly, efforts to regulate biodiversity loss, which in many cases have gone almost nowhere. So the role of international environmental law in this larger globalized system of environmental law requires re-examination, right? And I think that's clear in a number of contexts, perhaps best known the difficulties in agreeing on an approach to succeed the Kyoto Protocol and the climate change regime. One of the best illustrations of the problems with the current approach to regulating environmental issues, both at the global level and at national and subnational levels, is the fragmentation of the existing legal systems. Right? Legal systems regulation is broken into a number of issue areas and also broken by levels of authority. And both of these, I think, are important for understanding the direction that we may want environmental law to go to regulate truly global issues such as climate change. We can look quickly at the example of biodiversity law at the international level for an illustration of the complexity of this fragmentation, right? So international environmental law can be seen as a subset of international law, right? And it's broken down into a number of issue areas. These are just illustrative, not meant to be exhaustive. And then if we look within one issue area, biodiversity, we can identify at least 5 major regimes that seek to regulate components of biodiversity as an issue. We should also consider other regimes, such as the regime addressing forests at the international level, that try to regulate drivers of biodiversity loss. And beyond that, we need to think about the variety of national and subnational institutions that both try to implement these international agreements and also operate as domestic environmental law. Fragmentation is limiting on international environmental law for several reasons, particularly with regard to issues that are fundamentally interconnected in their sort of scientific sense or their occurrence in reality. The division of authority, according to issue areas, limits an integrated approach that would be most appropriate for dealing with some of these issues. An example of this can be the use of forests to sequester carbon without attention, for example, to its importance as a biodiversity habitat, without attention to its importance for ecosystem services such as provision of clean water. Now, of course, there's efforts to bring these things together, but the structure of international environmental law as it stands is not particularly facilitative of that. Also, inattention to the vertical fragmentation of law, meaning the fragmentation from the international to the national to the subnational, makes implementation more difficult. So we often hear law talked about in terms of hard law versus soft law, right? And in part, I think this is because the model that we're working from is that of national law, where we have a police power. So early attempts for international environmental law, something like CITES, seeks to really impose very clear restraints on what nations can do and create penalties in sort of a hard law model. Other examples of international environmental law, like, for example, the Rio Declaration, are purely soft law in the sense that they don't impose any requirements, but merely state aspirations, identify goals that we should move towards. There is a middle ground, of course, and that relates to the use of incentives, the use of encouragement, and facilitation. There's limited formal pathways built into existing international environmental law for ongoing dialogue between the national and the international. Instead, agreements such as the Convention on Biological Diversity, or perhaps more directly, the Kyoto Protocol, are set up as formal rule-based systems of law, where the international level essentially imposes requirements on the levels below, the national and the subnational. And finally, there are few formal incentives in any of these structures to encourage regulatory development, to encourage new approaches to regulating environmental issues, with a recognition that a lot of what we have done to date has been, at best, limited in its effectiveness. As the previous presentation made clear, one of the really important aspects that's getting us to think about how international environmental law is designed is globalization, right? It challenges a number of the ways that we've thought about international environmental law in the past. It highlights the existing fragmentation, because globalization is very much about interconnection between actors, problems, and authorities. The rise, for example, of non-state actors, both in terms of corporations and in terms of environmental NGOs, and their influence on both the approach to issues and the creation of problems. As a whole, the major international environmental regimes that we have today are not designed in a way that encourages building upon these connections. Most of these regimes can be thought of as self-contained, And this is true in most countries at the national level as well as at the international level. So specialists in climate don't think a whole lot about biodiversity, for example. And there's a limited ongoing dialogue between international regimes and the national or subnational entities that are supposed to implement them on the one hand, and also civil society and non-state actors. Right? There's some areas where this is more advanced and some areas where it's less so. Okay, so in the face of globalization, what alternative approaches to international environmental law appear or make sense? I would argue that globalization suggests a couple of needed changes in international environmental law design if we want to see it become more effective. Right? First, and I think this is pretty widely recognized, international environmental law cannot be primarily top-down. Right? The international level is not simply providing rules for implementation at the national level. State activities are increasingly interconnected, and non-state actors are increasingly important. This can create opportunities for both flexibility in implementation and for creating polycentric systems with multiple nodes of authority. Globalization also highlights something that I think has become increasingly clear in many national systems, and that is that a fundamentally command and control-based system which uses specific requirements that need to be met is unlikely to succeed at the global international level. Right? The consent basis of international law limits the ability to adopt sufficiently stringent requirements, and that's the problem that we see, I think, with finding a successor approach to the Kyoto Protocol, with the inability to bring developing countries into the Kyoto Protocol, with non-ratification by the United States. Right? The exclusive concentration on state commitments that we see in an agreement such as the Kyoto Protocol also limits the potential for successful implementation. Part of the reason for this is that it does not, in and of itself, encourage the type of experimentation and shared learning that will be necessary to tackle problems that are, in one sense, a fundamental challenge to the way that most nations have developed. Finally, the interconnections of globalizations offer an opportunity to develop new approaches for implementation, and I'll expand on that here. These opportunities, I think, involve both linking authorities in new ways and linking issues in a more fundamental way than we have been able to do so far. Right? So by linking authorities, we can incentivize in different ways. We can incentivize not only desired regulatory outcomes, but also an evolution in the approach to these issues that promotes learning, promotes better regulatory practices. Right? We can enable regulatory approaches that will reflect underlying issue linkages and are not as stringently tied to the fragmentation that we currently see in the setup of regimes, or say in the United States, in the division by media of air, water, etc., of our statutory regimes. Linking issues is important because it can promote synergies, beneficial synergies, and actually create opportunities for incentives that wouldn't exist if we look at one issue in isolation. They can also be cross-cutting and scaled to maximize benefits. The idea of polycentric governance that Louis mentioned aims to leverage the relationship among multiple nodes of authority to achieve regulatory goals. Right? And the work of Elinor Ostrom is probably the best known and most important on this. But the difference here is that the focus is on the relationship of authorities. Right? And so that's the move from the top down to something different. What would that something different be in the global environmental context? Well, I would suggest that polycentric global environmental governance would create international incentives for improving national and subnational governance of environmental issues. Right? Rather than trying to set hard numerical targets, create incentives for going as far as possible in a certain direction. Right? Rather than simply encouraging, create formal, recognized, supported incentives. Also promote context-sensitive implementation, experimentation, and shared learning. So an incentive approach, rather than a hard numerical approach, does encourage nations to look at their own context and to find the ways that will work best there, right? And of course, there is a need for internationally agreed boundaries. So one of the challenges to concepts such as adaptive management is that it's often a smokescreen and nothing is actually done, right? So some form of boundaries are necessary to address that. On the idea of linking issues, or what I would term linkage-based environmental law, international regimes are probably the best placed actors to look at building connections between issues into their programs and into the approach to environmental law in the 21st century. Thinking of law in terms of its linkages, much like thinking of governance in terms of the linkage of authorities, thinking of environmental law in terms of the linkages of the issues and of the relevant actors can enable a more holistic, big picture planning, right? And so the idea is to target those places where issues intersect as likely places for the best use of resources. So an example of linked authorities and linked issues would be a somewhat idealized form of the RED Plus regime that is in the RED Plus program that's emerging both within the UNFCCC and outside of it through a number of supranational actors and NGOs and domestic governments. We have funding from public and private investors creating an incentive for participation, not a hard law requirement, but an incentive. We have implementation through national and subnational law that has to conform to sort of outside boundaries of international law. The value of the RED Plus projects, and this is the part where it's really idealized, should be measured and assessed on the basis not only of its carbon impacts, but also the biodiversity and ecosystem services impacts, and on the human development or human well-being impacts, right? And sort of this triangle of assessment gives us a much more holistic picture. And then the incentives are based on the ability to meet those three goals. And the assessment is done not only at the national level, but by the international regime setting the rules, and also by non-state actors such as the Alliance for Community, Carbon, and Biodiversity. I think I mangled the name, but okay. So I realize that I'm out of time, but this system involves a linkage of authority that is both flexible and bounded by the goals, a linkage of issues that's tied to a particular ecosystem where those issues are relevant, forests, and it uses incentives in a way that promotes a context-sensitive and evolving approach that has multifaceted assessment, somewhere between hard and soft law. And this is kind of a diagram of what that might look like for those visual learners. And so the basic points, I guess, of this presentation are that linkage in the international environmental law, which I think is what globalization tells us we need, is both about authorities and about the issues. And if we focus on those two areas, we're likely to see greater success. Thank you.
Thank you, Andrew. Thank you for speaking time.
Okay. Good afternoon. Today I want to introduce Chinese energy conservation path and how it's complying. simply introduce some background of the climate change. I think everyone familiar with that. This is not a chart that very new, but that shows that China with a very large population and per person's emission, carbon emission maybe not so high, but the total amount is very high. So China government always faced a very heavy pressure of the international negotiation. But they always insist on the common but differentiated responsibility, because with the per person's emission amount or with the per capita of the carbon emission and with the history of the contribution of the share of all the carbon emission. So they insisted on that principle. But some international world may be complaining maybe China do not commit the obligation of the international convention. But as a scholar from China, I really observed that some interesting thing happened in China's emission reduction. In China, government's mind, they did a lot of work to do the carbon emission reduction. As the speaker just now mentioned, the soft law and the hard law. In China, environmental law is not so hard, but I think the emission discussion reduction is very hard. How it's be so hard? Maybe it's not only law can work. So that's why I found some very interesting thing in here. So in China, they not only, they mostly focus on the reducing of the energy intensity. That means the energy consumption in per GDP. So the target of the China's in the future, I mean the long-term target, maybe by 2020 it will reduce its energy intensity to 40% or 45 to 50%. So about the energy emission. So the second part, I want to introduce how to regulate all these things and get their goal. That's very interesting. China set a fixed target in its national plan. National plan in China is not law. It's just the 5-year national plan, what we call the social and economic national plan. That's our higher level plan all over the country. And in our the 11th 5-year plan, that means from 2005 to 2010, they have the energy intensity reduction about 20% reduction. So at the end of the 2010, they get about 19% reduce about the energy emission, and the carbon emission is 16%. And from this year, from last year, the twice energy emission reduction is 16%, and the carbon emission is similar, is 17%. So China has some very different background. The average global greenhouse gases emission from the source, maybe industrial is about 20, and energy supply is a lot of, and transportation. Compared with the US, mostly maybe the transportation reduction production, and some electronic power, and others may be residential, commercial, and industrial. But in China, because China recently what we call the world factory, so mostly the energy emission from the industrial, so that's maybe 60% or to 70% from the industry. So that makes some particular and very different strategy about the carbon emission. So what I mentioned, we set our goal in our national plan, and then others maybe still not from our law, that's from the policies. The policies are not law, meaning maybe they issued by the state council. It's not very firm law, but sometimes it's more practical. So I just give some examples about the directions, the decision of the state council, the notification of our state council that from year to year they give the name lists or some tasks to get the emission reduction of China's goal. So that's the two main resources about China's carbon emission reduction. First is plan, second is policy. So analysis the characteristic of China's enforcement of the carbon reduction. I think that's successful because, you know, from the chart we can see the goal is almost can be get, but the first character I think in China about the carbon emission is we rely on plans and policies rather than laws, which are more powerful. Why we think that's very strange? Why the policy or plan is more powerful than laws in China? First, I mentioned China, the environmental law is not so hard. But if you put some goals in the plan, maybe it's more hard because the principal officials accountability system related to that. That means if you cannot get the goal of the carbon emission, maybe your reputation, your promotion about some of the officials will be influenced greatly. So second, the strict target and periodic, updatedly 5 years, maybe 1 or 2 years with a different plan or different policies. So that makes sure maybe the plans and the policies can make some sense. The second character is in China, we're relying on more command and control methods at present time. Command and control is very important in existing Chinese carbon reduction. First, they gave the obligation to every province, this name of the province. Some maybe can get the 18% reduction, some 17%, and according to the different situations, they just divided all the goals to the different province. And furthermore, they they force every ministry and commission of the central government still have their own tasks. The second very obvious character about China's command and control in carbon reduction is about this, what we call maybe a kind of a movement, eliminating out-of-date production methods. That's what we call through old machines, that they give you a name list. In some years, you cannot use that again. So from this table, we know from the international world, command and control control is not so important, and many creative methods like cap and trade and carbon tax, they appeared. So in China, they increased some financial support for emission reduction. But the cap and trade is just trials and not so successful. But they try it in 7 big cities already with some more complicated problems and reasons. Maybe it's not can easily practice now. So why plans and policies are more effective than laws? I think because carbon reduction more related to the economic activities. So from the national plan, maybe you can be more easily to practice that. The second reason is that very simple and directly maybe related to the officials, so they will pay more attention to that. The third reason is in last time history China with a lower efficiency situation, so they can play a powerful effects than some just a very detailed cap and trade. The first reasons, I think, just as before, fixed goals, update goals can make things obviously to evaluated. So, but in the future, maybe China should face the modern methods again, because I think the command and control at present time is workable, but in the long term, it's not so easier to practice again and again. And in the twice 5-year plan, it's showed it's more complicated than before. So the third reason is, I think more and more what we call economics methods or market-based methods should be used more. So my conclusion is, in China we have a very special governance methods. That means maybe sometimes it's not so particular, it's not so common, but maybe they can play a great role in past. But in the future, we should keep up the piece of the international world and use more advanced methods. Thank you very much.
Thank you very much for being so quickly and to allow us at least one or two time for 1 or 2 questions. Can I quickly ask the speakers to come to the front, please? Could you all come and sit in front? And then I will allow at the most 2 questions, I think, because otherwise you will die of hunger. Are there any questions? At the back and then to my front here.
Yes, I'm Erkki Hollo from Finland. I actually liked very much the idea of having several environments and also then the global approach, and especially then the linkage between these which are available in the global context. But I wonder if we need actually a concept of global governance for the entire environment. Isn't it so that we have global environmental problems, and so we may also have global environments which are then in practice solved individually? Do we need actually a comprehensive environmental global governance? I think that's too bureaucratic perhaps to have such a, it's also difficult. I would say that the climate change issue, for instance, could be a global environmental issue, and but it's not necessary to apply that to all environmental issues, I think.
Okay. Thank you. Can we just have Ben at the back also? Can you take note of the question? Ben Richardson at the back.
You want me to speak now?
Yes.
I actually don't have any questions. There's just comments, and yes, they relate to Louis, Andrew, and Anel. Just to ways I think you might strengthen your papers. I mean, Anel, I'm sympathetic to your position about the criticism of the migration of corporate governance as a model for municipal governance for for sustainable development. But I think you talk about corporate governance models, but in fact there's only one model you talked about, which is the for-profit limited liability corporation. But in fact there's lots of different types of corporations. Here in Maryland there's a benefit corporation, which is a non-profit basis. South Africa itself has the Non-Profit Organisations Act. If you look at corporations historically, there were public charters, without the limited liability protections, without the for-profit making objectives. So I think that if you nuanced your discussion of corporations law, you would find, in fact, there are models that might be more sympathetic to be a model of good governance for municipalities. For Andrew, I think there was a little bit too much emphasis on the elegant design of institutional frameworks to create linkages and dialogue. When I look at the best example in the world that I know of that would meet the objectives that you set, I see an environmental disaster, and that's marine and fisheries law. You've got UNCLOS, the 1982 convention, sitting under that. It creates the framework for regional treaties, regional forums for fisheries management and protection of the marine environment. But the state of the world's fisheries, as we know from FAO and other studies, is disastrous. So it seems to me that there's something additional that has to go into the analysis there for institutional design. Louis, I mean, I love your work and I'm really looking forward to reading the book that's coming out very soon. When you define globalisation, your emphasis was all spatially. In other words, the breakdown and deterritorialisation of states and moving things to different scales. But space is not the only dimension of globalisation. There's also time, the temporal dimension. And what globalisation does is change the pace of time, for example, by allowing us to travel from point A to point B more quickly, the trade of goods, communications. And that has an environmental burden. And I think the globalisation of environmental law has got to think also about how it can help us to think differently in terms of time, as though the future mattered, thinking in the long term, being more patient. And we only have very embryonic principles for that, like the precautionary principle, intergenerational equity. So I don't expect anyone to comment from that. They're just some takeaways. But I liked your papers.
And I will invite to my Morombo. If you keep it short, you might.
Thank you, Philomene. I'm Tumai from South Africa. I have a question for Louis and Andrew. What are the implications of this new concept of global environmental law on international environmental law? I see potential benefits in terms of its expanding the scope of actors that could be involved in terms of assisting with the implementation of international environmental law, a point that Andrew pointed out. But I want to understand, going forward, how do you see global environmental governance interfacing with international environmental law? What's the connection? What are the possible implications in terms of aiding to effectiveness of international environmental law? Thanks.
Okay, thanks. Louis, do you want to start?
Perhaps just to very briefly respond to Mai's issue, and thank you also for the comments that were made, is that if you think of global environmental governance in terms of governance and in terms of this idea of the global, which quite rightly my emphasis is on the spatial aspects thereof, Ben, then it forces you to acknowledge that law is not the only instrument to achieve regulatory outcomes. In other words, it forces us to redesign and to rethink of how we approach our regulatory interventions. To what Andrew said, and even in the last paper, where we move from hard legal instruments to softer law-like instruments, which are nevertheless normative and which could have a tangible impact or positive result as far as changing human behavior towards the environment is concerned.
Okay, Andrew, do you want to add?
Yeah, I'll just say a couple of words about something I left out of this presentation to bring in elements that I haven't talked about before. And that is, when I talk about the linkage of issues, one thing I've made clear in a couple of past articles is that if you look at the literature using this term linkage, most of it, the vast majority of it, talks about institutional linkage, right? And I think that that really is a mistake. What we want to focus on is linkage of issues, right? Because the concentration on building in sort of an elegant institutional architecture to get one regime to talk to another or to talk to certain national governments, I think often misses the point and leads to a lot of sort of bureaucratic buildup without a whole lot of results. But if we look at international regimes as they are positioned now, and particularly the climate change regime, it has a real opportunity to bring together in programs on the ground in places like Africa multiple issues, bringing together actors that affect it from various ends of the spectrum, including NGOs who want to focus on development or reforestation, and corporate entities who are looking perhaps for some good PR and also for potentially an investment in carbon down the road. And so I think the institutional design really is not the emphasis of what I'm talking about. And part of the point is that we've given perhaps too much attention to the overarching institutional design, and we need to think a bit more about how this comes together on the ground, because that's where our mistakes have been.
And thank you all, and thank you to our speakers for attending. You may now exercise your right to food, but you have to be back at 13:30 sharp for the next session. Thank you all for attending the session, and thank you for our speakers for all their efforts. Thank you.